Hello everybody, welcome to 5ELW, and this is the first video of 8. You've got some insight now as to what the unit involves. It's challenging and it's interesting, and probably more so than the other units, there's a lot of right and wrongs with 5ELW or employment law. For example, legislation is specific. It may need some interpretation, but a lot of what you're studying is sort of non-negotiable. For example, new recruits are entitled to a written statement, and that has to be issued within 2 months of starting. And the items that go in the written statement are identified. There's sort of 17 of them in fact, including place of work. So it's really important that employers understand exactly what they've got to do. Some employment law can involve discrimination, and for example indirect discrimination, which we'll sort of come up with in later units. But the interesting case here of Mrs. Crilly, who applied for a position with the Bournemouth Community Centre in Northern Ireland, and the position advertised required 2 years paid work experience in the last 5. Now Mrs. Crilly didn't have that, but because she'd been off for 6 years to bring up her family. But in all other respects she considered herself a good candidate, and was expecting, possibly to be interviewed or even to be offered the job. However, she got turned down on the grounds that she hadn't got the experience. She thought this was unfair, appealed, and it eventually went to an employment tribunal, who upheld her claim. And the basis of that was that they said whilst the Bournemouth Community Centre sort of desired to get experienced people was legitimate and understandable, its effect was disproportionate. In other words, it had the effect of excluding people like Mrs. Crilly, who in all other respects was suitable for the position, and therefore it held in her favour on the grounds of sex discrimination. And I think there's important learning for us here on employment law, that sometimes we may lay down a requirement in the job spec or in the job ad without fully understanding that it has got the effect, just like in Mrs. Crilly's case, of disproportionately prejudicing certain groups from applying or being seriously considered. These short videos are designed to enthuse you, to set the scene very quickly. Not a lot of detail will be covered in them, but the headings of what you need to learn will be mentioned. You're aware that there are 2 books. The core textbook is Employment Law, the Essentials, and there's a smaller textbook which is useful for sort of quick reference and topping up knowledge, or just checking that perhaps you've got something right in the assignment. Please use the flexible learning approach that's central to this unit. For example, the videos, reading, sharing knowledge in your set, working together in the set on answers to questions like the forced choice, and working with the set obviously for the final week when you'll be sort of running a session for the rest of the group. Employment law has changed enormously in the last 50 years. I can look back to the 60s when there's very little employment legislation, but now there's a considerable amount. Much of this actually came in the 1970s, for example, the Health and Safety at Work Act. And I think most people feel that the world is a much better place for this legislation to protect people against sort of things like discrimination. It's not been perfect. I mean, some legislation hasn't completely worked. For example, equal pay has been in for 35 years, but there are still instances all the time of unequal pay between men and women in particular. And that remains a challenge. But this is a super unit, lots to get into. It's interesting and challenging. As I said at the outset, you'll learn things in this unit that will stand you in stead as a practitioner for many years ahead. Good luck and thank you for listening. Hello everybody, welcome to the second video, ERW2. We're going to be looking here very briefly at chapters 1, 2 and 3. So each video from now on will look at 3 chapters, and then that will take us through 6 videos, and there'll be one final video to sort of give an overview. So I'm going to move pretty quickly through the chapters. But chapter 1 is about sources of law. How has employment law arisen and where has it come from? Well, you're going to read quite a lot about legislation, Acts of Parliament. In particular these days, many Acts of Parliament are as a result of the European Union and their sort of directives, which are then interpreted in Parliament or followed in Parliament more accurately, and then implemented as an Act of Parliament. Case law is also very important with employment law. There are sometimes precedents, and sometimes case law helps to determine exactly how an act should be interpreted. I mean, an example here is age discrimination. The legislation has been around for a couple of years, but it will often need case law and instances of claims in tribunal for interpretations to become clear, and then those interpretations become precedents. There's a sophisticated structure for ensuring that employment law is followed and adhered to, and people have the right of appeal. For example, there are employment tribunals, employment appeals tribunals, courts of appeal, Supreme Court, House of Lords, and so on. So there's a sort of a staircase of levels. Codes of practice are very important, as you'll read. For example, ACAS codes of practice are not, strictly speaking, the law, but they're very close to it. For example, employment tribunals will use codes of practice to guide them, and if employers haven't followed codes of practice, and there's no good reason for this, then their case will be significantly weakened, or, to quote, will be taken into account, close quotes. Another important body is the CAC, or the Central Arbitration Service. They have a role in helping to determine whether trade unions should be recognised. Perhaps an employer is doubtful whether there is support for a trade union, and the CAC will become involved and perhaps arrange ballots and so on to establish exactly what the interest is, and then sort of make a decision about whether the employer should recognise a trade union. And also the CAC get involved where perhaps bargaining groups like trade unions claim that they're being given insufficient important information for bargaining purposes. Unions form an important part of Chapter 1. They must be registered. By registering, they enjoy a certain amount of protection in law. For example, if they call a strike, being registered protects them from being sued for damages, but providing they've met other requirements, for example, perhaps calling a ballot, making it clear to the employers the action that they intend to take and when, and so on. Chapters 2 and 3 are very much around contracts. We're going to learn that some clauses in contracts are express, they're written, and it's very clear what is meant and intended, but other requirements in a contract are implicit. After all, not everything can be included in a contract. I mean, a contract, for example, doesn't always state how we should dress, or necessarily how we should behave towards customers. We're going to also discuss and learn about collective agreements. These are typically negotiated between employers and a trade union or trade unions. They would affect all those people in a bargaining group. Some of those may not actually be union members, and some people within that bargaining group may not agree with what has been decided. But the collective agreement has the effect of imposing and implementing the agreement on everybody. We're going to talk a bit about works rules. Do they get included or don't they in the contract? Well, there's no sort of black and white answer to that, but the answer is, in all probability, yes, some work rules. There is an issue with contracts about being a little cautious about putting everything into the contract, because as we're going to learn in later chapters, changing the contract without agreement or arbitrarily is quite a serious breach for employers. So employers do need to think very carefully what they put in a contract, and not every work rule would perhaps necessarily be contractual. That's a debating point. Customer practice forms an important part of contracts. An arrangement may have gone on for a long time, several years. It's never actually been written into a contract, but by customer practice it is effectively become contractual. And often tribunals, when there is a dispute and it's unclear whether this is within a contract or not, a tribunal will ask a very important question: well, what actually happens? I mean, how does it work at the moment, or how is this person rewarded for doing this or for doing that? So customer practice is very important. Some terms are implied, as we said. I mean, for example, statutory requirements are implicit within the contract. I mean, the employer wouldn't be setting up a contract that is intentionally breaching the law of the land, or at least one hopes they aren't. And there's obligations on employees, I mean, for example, to work safely and to not disclose confidential information to customers and third parties. So, a lot to get into with chapters 1, 2 and 3. It's about the sources of law and it's about contracts. I hope you enjoyed. Do work through the Q&A questions at the end in your set with a colleague. See if you can try and get the right answers to those. Keep reading the chapters in the book and the shorter, easier, easy reading sort of book on employment law, which was issued with the main book. And see you soon. See you with video 3.